5 seconds to go. Start. Pandit Jawaharlal Nehru, after his historic Tryst with Destiny speech, unfurled the tricolour from the ramparts of Red Fort on 15th August 1947. That singular event symbolized the end of the British rule in this country and the birth of an independent India. An event that is relived and reacted every succeeding year since 1917, when every incumbent Prime Minister addresses the nation from atop this great and historic fort, reminding the countrymen of the importance of freedom, the need for its preservation, and the values of constitutional democracy that guarantees the freedoms so very fundamental to the preservation of the unity and integrity of this country. An attack on a symbol that is so deeply entrenched in the national psyche was therefore nothing but an attack on the very essence of the hard earned freedom and liberty so very dear to the people of this country. An attack on a symbol like Red Fort was an assault on the nation's will and resolve to preserve its integrity and sovereignty at all costs. It was a challenge not only to the army battalions stationed inside the monument, but the entire nation. It was a challenge to the very fabric of a secular constitutional democracy this country has adopted and everything that is good and dear to our countrymen. It was a blatant, brazen faced, and audacious act aimed to overawe the government of India. It was meant to show that the enemy could, with impunity, reach and destroy the very vitals of an institution so dear to our fellow countrymen for what it signified for them. It is not for no reason that whosoever comes to these reasons that this place has become a place of honor for Indians. No one can ever forget the glorious monuments when the Indians, irrespective of their religious, fought their first war of independence and shed their blood. It was therefore but natural for the foreigner enemies to plan an attack on the army specially kept to guard this great monument. This was not only an attack on Red Fort or the army stationed therein, this was an arrogant assault on the self respect of this great nation. It was a well thought out but insult offered to question the sovereignty of this great nation by foreign nationals. Therefore, this case becomes a rarest of the rare case. This was nothing but an undeclared war by some foreign mercenaries like the present appellant and his other partner in conspiracy, Abu Samal, and some others who either got killed or escaped. In conspiring to bring about such kind of attack and then carrying out their nefarious activities in systematic manner to make an attack possible was nothing but an attempt to question the sovereignty of India. Therefore, even without any reference to any other case, lo, we hold this case to be the rarest of the rare case. During the whole debate, the learned defense counsel did not attempt to bring any mitigating circumstance. In fact, this is a unique case where there is one most aggravating circumstance that it was a direct attack on the unity, integrity, and sovereignty of India by foreigners. Thus, it was an attack on Mother India. This is apart from the fact that as many as 3 persons had lost their lives. The conspirators had no place in India. The appellant was a foreign national and had entered India without any authorization or even justification. This is apart from the fact that the appellant built up a conspiracy by practicing deceit and committing various other offences in furtherance of the conspiracy to wage war against India, as also to commit murders by launching an unprovoked attack on the soldiers of the Indian Army. We was the only sentence in the peculiar circumstances of this case. We therefore have no doubts that that sentence was the only sentence in the peculiar circumstance of this case. The decisions referred to in the written submissions show that when there is challenge to the unity, integrity, and sovereignty of India by acts of terrorism, such acts are taken as the most aggravating circumstances. It is well accepted that the cumulative effect of the aggravating factors and the mitigating circumstances must be taken into account before the death sentence is awarded. In Vasanta versus State of Maharashtra, while dealing with a case where death sentence was awarded in a crime relating to offences punishable under sections 302, 363, 367, 376 2F and 201 of the IPC, this court had observed that the aggravating circumstances had clearly outweighed the mitigating circumstances. Stop.